get us started anyway. My name is Matthias Risser. I'm the director of the Carr-Ryan Center for Human Rights Policy, and it is my honor and privilege to open this event and just to speak a couple of sentences about how this fits in with what we are generally doing at the Carr-Ryan Center right now. And of course, first of all, to welcome you all. So thank you to all of you who are spending this time with us this morning and this afternoon. Thank you especially for this very distinguished set of speakers who is joining us for this event. We are truly excited to have you to look back at 20 years of the Rome Statute. So the program is truly exciting. So a little bit about the general context at the Carr Center. So as you probably all know, this is a year of a lot of anniversaries in the human rights domain. So there is of course in a way, the biggest one of them is the 70th anniversary of the Universal Declaration of Human Rights itself, which is coming up in December. So we're going to have a big event on that on December 7th here at the Kennedy School, which is meant to be the university-wide event honoring that occasion. Then, of course, there's also the 70th anniversary of the Inter-American Declaration of the Rights and Duties of Men. And this one today, that we're honoring today, the 20th anniversary of the Rome Statute. Yeah, so it's a year of anniversary. So this is the human rights domain. So anniversaries are never purely an occasion for celebration because it's human rights issues. Right? So we know that human rights is about taking the perspective of the underdog. It's about making sure that power is used in such a way that people actually benefit from that rather than that power takes advantage of them. And there's always much more to do than has been done already. But nonetheless, on occasion, and birthdays are occasions to do that, it's also good to think about how far have we come, what has been accomplished, where are we falling short, and it's an exciting thing that we're doing that today for the Rome Statute. So as you probably all recall, at the very beginning of the preamble of the Universal Declaration, the terms justice and peace are standing next to each other somewhat innocently, right? So justice and peace, and that by itself is actually quite an accomplishment in the larger sweep of human history, that justice and peace are being thought together. And of course, if you live under lucky circumstances, then you have some version of peace and some version of justice. But then there's big questions arising. What do you do if they get lost? I mean, what are we doing if we live in societies where justice and peace have gotten lost? How do we come back up? Right? And in this process of coming back up, what is the relationship between justice and peace? In particular, how much should justice be prioritized in order to get to peace? And that's a big question on which there's been a fair amount of experimentation. Also in the post-war period, different things have been tried in different societies. A fair amount of academic reflection has been done about that. The Rome Statute takes a very clear stance on that. Right? It says both as a moral matter and as a practical matter, the kind of peace that we want is the kind of peace that includes certain kinds of justice, right? And then it has this range defined where the International Criminal Court is supposed to be operative. So the idea is a peace that doesn't do that kind of justice is neither worth having nor stable. Yeah? So that's very much how I read the commitments made by the Rome Statute. And so the Rome Statute is now turning 20 years old. It's a good time to look back at this. The Rome Statute, as all the MPPs know in the room, is also very much alive in the halls of the Kennedy School right now, because just a couple of days ago we had President Santos from Colombia visit all our MPP classes and talk about how the ICC, how the Rome Statute fed into the peace process in Colombia, since the idea of the Rome Statute and the ICC has always been not just to be a court that looks at crimes that already happened, but also to be a reference point that can be used to make sure that bad things don't happen in the first place and to inform domestic processes. And as I was mentioning yesterday at the dinner already, so President Santos said repeatedly that the ICC and the Rome Statute was flying around in Colombia like a phantom. And I mentioned that to Luis Moreno Ocampo, and he declared victory on the mission of the ICC, that this is exactly the kind of use it was meant to be put to. So without further ado, allow me now to introduce my distinguished colleague, Catherine Sicking, who is the Ryan Family Professor of Human Rights Policy, and even more importantly for this occasion, the author of this wonderful book, The Justice Cascade, which maps this whole territory of trial and error and successes and failures in the 20th century that eventually led up to the Rome Statute and and the ICC, so there's no better person to organize this event than to guide us through the day. Please join me in welcoming Kathleen.
Thank you, Matthias, for that introduction. And I wanted to say that the coffee has arrived, and so let's get important things first. And I'm going to give everyone permission who wants to get up and get coffee to do it now while I'm starting my talk and before the panel begins, so please feel free to do that. So today we are here to remember and to reflect on the 20th anniversary of the Rome Statute. We'll be looking forward and backward, as the program says, considering both the developments of these last 20 years and the challenges for the future. And our idea is to look back, to take stock with an eye towards moving justice forward in the future. Now, and by the way, while we go, I also want to invite my panel to already come up here, because I'm going to segue from my remarks directly into the panel. So Luis and Karen, do you want to come up and get ready for our first panel, which will begin right after my remarks. Very brief remarks. So for some of the students in the room, and I know there are students in the room from my Politics International Law class, 20 years seems almost a lifetime. You may not realize that for many of us for whom 20 years ago doesn't seem that long ago, the demand, in the mid-'80s still, the demand for an international criminal court seemed almost unimaginable. It seemed unimaginable that there could actually be an independent international court that had jurisdiction to prosecute individuals who committed mass atrocity, including even heads of state. And so really what I want to stress beginning, now we sort of come to take for granted, of course there's a national criminal court, but I want to stress at the beginning how unexpected this development was. And the demand for a national criminal court had been present since the 1920s. It was given new impetus after World War II with the Nuremberg and Tokyo trials. And of course, treaties were also ratified after World War II that began to provide underpinnings for individual criminal accountability, especially the Genocide Convention and the Geneva Conventions. And so around that time, members of the United Nations asked in the General Assembly, asked for the creation of an international criminal court. And they called upon the UN's International Law Commission to draft a statute. But when the International Law Commission came to the General Assembly with that statute in 1953, 1954, it was rejected, okay? Now remember, the Cold War had now begun, right? And post-war expectations of collaboration among the great powers had evaporated. And so basically this demand for a national criminal court disappeared, languished for over 30 years. And so that was when it began to feel like an impossible dream, almost like only naive idealists mentioned the possibility that there might be an international criminal court someday. But it was resurrected in 1989, initially by Trinidad and Tobago, in a much more promising moment. And also shortly after, 1993, the UN Security Council created 2 ad hoc tribunals, one for the former Yugoslavia and one for Rwanda. And so those also created some models and, of course, some impetus, demand for a permanent international criminal court. And so the ICC process started to move quite quickly at that point, and the court was created in what we now know was a slim window of opportunity between the end of the Cold War and 9/11, the beginning of what some people call the War on Terror. But of course, the ICC created a new model as an alternative to a war on terror, right? And it was a model of using law to fight crime. Now, the ICC came to embody many of the aspirations for justice and human rights that were so prominent in that moment. And these high hopes were evident in Rome as the delegates concluded 5 weeks of deliberation, and the conference adopted the statute by a vote of 120 in favor, 7 against, and 21 abstentions. And at that moment, and I wasn't there, but Judge Prost was there and others were there, but I've seen the video where the delegates broke out in a spontaneous and extended standing ovation for the adoption of the statute. And I think that when you see that video of the standing ovation, you get an idea of how kind of unexpected and almost euphoric was this moment. Now, I want to signal, though, that the ICC was part of a broader system. And Matthias mentioned my book, The Justice Cascade, and one of the points I make in that 2011 book is that the ICC was part of a bigger system of increasing legitimacy for a norm of individual criminal accountability in the world for mass atrocity. And we saw that not only with the ad hoc tribunals, not only with the creation of the ICC, but also with an increase in domestic criminal prosecutions for mass atrocity in countries around the world that ranged from Greece to Argentina, where Luis Moreno Ocampo was, of course, the associate prosecutor of the trials of the juntas, some of the earliest trials in the world of state leaders for mass atrocity. So the Rome Statute itself, with its doctrine of complementarity, okay, where the statute, the court has jurisdiction only if a state has been unwilling or unable to prosecute domestically, in fact embodies this larger system. And so when we evaluate the court, it's really important to realize that we're evaluating the whole Rome system and not only what happens in The Hague. Right? People make that mistake sometimes. One of the things I like so much about Beth Simmons' research, that she's going to present later today, is that it's really an attempt to see, can we evaluate the Rome system more broadly and not only the cases under investigation in The Hague. So, and I should say that the founding prosecutor, Luis Moreno Ocampo, is here with us today, immediately understood the implications of this broader system and designed his strategy accordingly. So, so in the language of our colleague here at the Harvard Kennedy School, Robert Putnam, basically the Rome Statute and the International Criminal Court transformed what was a one-level justice game into a two-level game. In other words, the one-level game in the old days, when powerful officials didn't want to be prosecuted, they were able to block prosecution because they had power in their domestic setting. In the two-level game, all of a sudden you had this international level that could bring pressure to bear and could change that domestic game. And that's exactly the point that President Santos was making to the MPP ethics courses. He was saying the shadow of the ICC in the Colombian case, Colombia was under preliminary examination by the court for many years, and that shadow of the examination, without any investigation open, nevertheless had a very distinct impact on domestic negotiations for peace and justice in Colombia. So I think it's a really good example of how the ICC makes it a two-level game. And I just should say that it seems likely that President Santos may show up at our a conference today, maybe around this afternoon sometime, and will perhaps say a few words about his own experience. So, of course, like all institutions that embody our highest aspirations, in the real world of politics and law, they inevitably fall short. And certainly you are all aware that there was also a wave of pessimism and critique of the ICC in these first 20 years. So I think now that we're at this 20-year anniversary, it's a good time we can put behind both the initial euphoria and kind of this sort of deep disillusionment and engage in rigorous reflection and analysis about the past with some realistic thoughts about the future. We have an amazing group of scholars and practitioners, and we're particularly privileged to have with us ICC Judge Kimberly Prost, OES Secretary General Luis Almagro, who will be coming this afternoon, and of course, the founding prosecutor of the court, Luis Monero Campo. Now, I believe that people in the future will look back at the moment of the creation of the ICC as one of those institutional inflection points in history where something quite new is created. But the future is still being written, and some of the people in this room are in the process of writing it. And so let's move on to them. Now, I'm going to now switch from my role as doing the introduction to my role as moderator of this first panel. All of the people who registered for this conference received an extended program that prepared, by the way, for us by Carr-Ryan Center staff. And I just do want to briefly say, please come up. I just want to briefly say thank you here to the Carr Center, to our executive director, Sushma Raman, and to our staff people, Sarah Peck, Jetta Brown, who I don't see right now, but I'm sure she's doing some important business for the conference, for all of your work in bringing this together. Anyway, Jana sent out to all of you who registered a full program with full bios of all the participants. And so I'm not going to just read those bios again. I'm going to say a few words about each of our panelists in this morning panel. We're going to start with Karen Massotti. She is the head of the New York Liaison Office of the ICC in New York. So she'll maybe tell us more about it. It's the office that works with all the states parties of the ICC. She is currently on leave to attend the Harvard Kennedy School Mid-Career Program. And so again, I just want to say how this gives you an idea of the quality of some of the students we have here at the Kennedy School. And we're so fortunate to have Karen Massotti with us this year and on this panel. After Karen, I believe Luis Monero Campo will speak, founding prosecutor of the court for its first 9 years. He's been a friend and colleague for many years, and is currently an important senior fellow here at the Carr Center. And he is in the process of completing a book manuscript on his work at the court, and I think will speak about that work. And finally, Beth Simmons, a university professor at UPenn. She's a political scientist, an international relations specialist, and this year, to our great good fortune, she is a fellow at the Radcliffe Institute, so she only had to come across campus to be here today. But Simmons is simply also one of the most influential IR scholars, period. Also a major expert on human rights, international law, and global justice. So welcome to all of you. Thank you for being on the panel. I have given everyone 12 minutes. I'm going to keep time, and I'm doing that because we want to begin already our dialogue with you, and so we'll make time for questions and answers in this session. Thank you.
Good morning, everyone. Thank you, Catherine, for that excellent introduction. I'm really privileged to be here this morning, and I thank the Carr Center and Professor Catherine Sinkink for inviting me to be here. As she said, I'm currently a student at HKS, part of the mid-career program, on leave from my job at ICC in New York. And she asked me to speak on this panel. Basically, she asked me to reflect on my experience at ICC, working for ICC in New York, and to share some of the perspectives I have picked up over the years working for ICC. And I would probably go back a little bit to my experience prior to joining ICC when I worked as in the foreign service of the Kenyan government, because my journey with ICC begins before I joined ICC. But before I go into my remarks, let me just put this caveat that today I speak in my capacity as a student and not as an ICC official. We have Judge Prost, who is going to speak on behalf of the court. So whatever I say cannot be attributed to the court or to any official capacity that I hold in the court. So I'm going to approach the remarks today from a very personal perspective. I'm going to go through my experience, my interaction with ICC, when it began and how it has evolved over the years, and along the way I will be able to share some of the issues that have been raised by Professor Sekink, the challenges, the disillusionment, the excitement at the beginning. I hope you'll be able to pick up all of that from my story. So ICC is celebrating 20 years this year. As of 17th July of this year, ICC is 20 years old. That is the commemoration of the adoption of the Rome Statute, as we heard from the background from Catherine. But my journey with ICC actually began about 16 years ago, when I was working for the Kenyan Foreign Ministry. I was working in the legal department, and frequently I would get memos from our then legal advisor in New York regarding the ICC, because usually the legal advisor posted to the permanent mission in New York is the one who handles ICC in the interactions at the UN. So I had a very distant relationship with ICC at that time. But then in 2002, I took leave from my job at the Foreign Ministry to go for graduate studies at the University of Nottingham in the UK. And 2002 is the year that the Rome Statute entered into force. So as part of my graduate studies, I was studying for an LLM in human rights. ICC was a big part of that, the class discussions. And of course, because everybody was so excited about ICC, we were all, as students, we were all gravitating towards studying international criminal justice, the ICC, the ad hoc tribunals, and of course international humanitarian law. So that kind of sparked my interest in ICC, and I got hooked into the idea, and that has been my journey since then. I have followed that path, working with ICC, advocating for ICC, and prior to joining ICC, representing my government in discussions relating to ICC. And I was fortunate because immediately I finished my graduate studies, my government sent me to New York as a legal advisor to the permanent mission, replacing the previous legal advisor who had been there. So I arrived in New York in 2003. The court had just been set up, and there was so much excitement at that time, the euphoria that Catherine was talking about. And of course, I joined the euphoria. At that time, Kenya was not a state party. They had been in Rome, they were part of the negotiations. They had signed the treaty, but they had not ratified. So one of the things I had to deal with in New York as a legal advisor for the government of Kenya is to basically respond to all the lobbying efforts targeted towards Kenya. There were the ICC States parties, and at that time mostly they were European countries and Latin American countries, had this intensive campaign to recruit more states parties to the Rome Statute. And of course I was the target of that campaign, and because of my previous experience in Nottingham, I was not very difficult to convince. So I took it upon myself to try and convince my government back in Nairobi that it was worthwhile to join the Rome Statute. So of course there was back and forth. Unfortunately at the time in Kenya also, a new government had just been elected, the first democratic government actually, after about 25 years of dictatorship. The democratic government was elected in 2002, and they were of course very keen on aligning Kenya's foreign policy with international standards. So ratifying the Rome Statute was one of those projects undertaken by the then government. The president at that time was Mwai Kibaki. And then we also had a very active National Commission on Human Rights, which at the time was headed by a prominent human rights activist, Maina Kiai. And of course, he was also lobbying the government to the Human Rights Commission and other NGOs on the ground were lobbying the government to join the Rome Statute. So eventually, the Attorney General presented the bill to the legislature, and the legislature approved the ratification. But then the executive at that time had a dilemma, because that was the time during the Bush administration when they were actively fighting ICC. And they had this what we called a bilateral immunity agreement at that time, and they were basically approaching a lot of countries, especially developing countries, asking them to sign that bilateral immunity agreement, the effect of which would be to commit to not ever surrendering American citizens to the ICC. And of course, they were threatening to withhold military aid that they were providing to many governments and to the Kenyan government at that time, that if you don't sign this, we are going to cut all aid to your military. So it was a dilemma for the government. But because this was a government that was interested in aligning itself with international standards, somehow the legislature was positive towards the ratification, and eventually in 2005, Kenya ratified the Rome Statute. And now, so Kenya ratifies the Rome Statute, and then of course we got involved, became a very active member, an advocate for the court, both at the UN and within the African Union. And then at that time I was in New York, so I was basically representing Kenya in all negotiations relating to ICC, and a lot of the meetings on ICC were held at the UN in New York because a lot of the member states of the ICC are based in New York. But then something changed. That support for the court in Kenya changed around, let's say from 2007. And I want to share the Kenyan experience as an example of what is happening within Africa and the journey that African countries have basically walked through from the time when they were in Rome, actively involved in supporting the adoption of the Rome Statute, to where they are today, where there are signs of disillusionment with the system, and they are openly and publicly criticizing the court all the time. So the Kenyan experience, I use it because it's just an almost perfect example of what is happening in Africa and why Africa is resisting the court at this point in time. And what happened in Kenya in 2007 is that there was a disputed election that led into violence, fighting between supporters of the then incumbent and supporters of the opposition, and a lot of people were killed. And the former Secretary General of the UN, Kofi Annan, was brought in to mediate peace. And eventually they signed a peace agreement that allowed for a coalition government between the opposition and the incumbent government. And part of that peace agreement required that a commission be established to investigate the post-election violence. And a commission was set up, headed by a Kenyan judge called Wake. And at the end of the commission's work, they made recommendations to establish a national tribunal to look into, to prosecute crimes relating to the violence, and failing which, then the matter would be referred to the ICC because Kenya was already a state party. When the draft bill to establish the tribunal was presented to Parliament for adoption, the Parliament voted against it. And the debate in Parliament at the time is that they did not trust the Kenyan judicial system to be impartial enough and independent enough to adjudicate the matter, because it was a very political matter, and of course the judiciary in Kenya is perceived as impartial because the judges are appointed by the president. So when the establishment of the tribunal failed to take place, Kofi Annan, who was in charge of the process, of course, then sent the brief to the then prosecutor, Luis Moreno Ocampo. And so at the beginning, Kenya was not was not openly opposing the process. And I remember the prosecutor went to Nairobi, and when he announced the opening, because he used his powers as a prosecutor, the promoter powers to open the investigations in Kenya, he went to Kenya, and he stood there outside the president's office with the president. It was a coalition government at the time, the president and the leader of the opposition, who had then become a prime minister, and they announced that he was going to begin the investigations on Kenya. So that went on, but as the process moved forward and the names of those who were suspected of committing crimes were announced, there was a negative reaction in Kenya, and that's because some senior political leaders were named. At that time, one of them was the Deputy Prime Minister, who is currently the President of Kenya, Uhuru Kenyatta, and there was a minister from the opposition side, William Ruto, who is currently the Vice President in Kenya. And of course, because at that time they were not president or vice president, but they were senior government officials. So of course there was lukewarm reaction by the government to the proceedings in The Hague. But I will let the prosecutor maybe talk to the details of the relationship that went on between the office of the prosecutor and the Kenyan government. But what I'm trying to say is that the resistance to ICC in Kenya started as a result of that. And then in 2013, the previous president, after serving 2 terms, retired, and there was an election. And the 2 indictees by ICC, basically the current president and the vice president, ran together on the same ticket, and they won the election. And from there was zero cooperation. It was an open war against ICC. They went to the African Union and mobilized the African Union to start, issuing statements against the ICC. They mobilized the African Union to go to New York to the Security Council and try to influence the Security Council to suspend proceedings against the then Kenyan president and vice president. They also appealed to the ICC States parties, the 124 States parties, basically asking them to consider amending Article 27 of the Rome Statute. Article 27 is the one that strips the immunity of sitting heads of state. So they wanted the states to go back and amend that provision to allow for immunity for sitting heads of state. Of course, they did not succeed. They also even approached the court, directly met with the president and asking the president to basically that the court should consider dropping the charges against the 2. Of course, none of those initiatives worked. At the Security Council, thanks to the many ICC supporters who are member states of the UN, and some of them within the UN Security Council, France, UK, and surprisingly at the time, it was during the Obama administration, even though the US is not a state party, they were actually siding with the ICC states parties. So of course, the initiative to get the Security Council to stop the proceedings did not succeed. And the African Union, of course, continued to agitate and started threatening to withdraw from the Rome Statute. And actually, in 2016, 3 African states, Burundi, the Gambia, and South Africa, notified the Secretary General that they were going to withdraw from the Rome Statute. Even though by that time the charges against the Kenyan officials, the president and the vice president, had been dropped by the court itself for lack of sufficient evidence. Of course, there were other factors. The judges found that there had been massive interference with witnesses. But then African countries continued the discussion about withdrawing from the Rome Statute because they thought ICC and the Security Council and the ICC states parties were not listening to their grievances. When Burundi went on to withdraw, South Africa and the Gambia did not. The Gambia, there was a change in government and they revoked the notice to withdraw. And in South Africa, an NGO went to court, and the South African High Court held that the decision by the South African government to withdraw from the Rome Statute was unconstitutional because it did not go through the necessary legislative process. So in the end, it's only Burundi that withdrew from the Rome Statute. So that's just a brief history of how Africa has reacted to the Rome Statute. And just to cap it all, at the end, after the charges against the 2 Kenyan leaders were dropped, somehow the tone against ICC started going down, the criticism went down. It continues, but it's not as amplified as it was during the course of those proceedings. And that brings me to the question, and which, as we celebrate the 20th anniversary, I think given that history of interaction between Africa and the ICC, I think we need to ask ourselves, why was Kenya, and by extension Africa, resisting? And I must mention that there was, the president of Sudan had also previously been indicted by the ICC, and there was a reaction from the African Union. But for some reason, Sudan was not able to mobilize the African Union in the same way that Kenya did. So then we ask ourselves, why does Africa resist the ICC? And if we look at the story that I have just given, there was a lot of support at the beginning. And then when the leaders were indicted, the support went down. And the charges against the leaders were dropped, and now the support is kind of coming back. It's still not as high as it was in 1998, but it's coming back. And I think that's the question we need to ask ourselves every time we say that Africa is against ICC. In my view, I think Africa is not against ICC. There is a reason why, even though they keep threatening to withdraw, they haven't done it. They continue to be members, active members of the ICC. They attend meetings, they contribute, they cooperate with the Office of the Prosecutor. In my view, the resistance only arises when senior leaders are being targeted. It's not because Africa in principle is against the ICC. And if you talk to the African victims, there is great support for the International Criminal Court, aside from the leaders. So that's the question I would like you to reflect on as we celebrate the 20th anniversary of the Rome Statute.
Yeah, thank you very much. Of the 20 years of the ICC, I had nothing to do with the first 5 years. I was never in Rome. I received a phone call in 2002, calling me saying, we put your name in the list of candidates to be the chief prosecutor. Now your name is on the top. We have to know if you are interested in the job. I was thinking, it was like funny, but nothing would happen. I was very happy coming to Harvard in those days. There was a PhD professor at Harvard, and I was delighted with that. But it did not happen. And then for 9 years, I spent 9 years at the ICC. And my last 6 years, I'm trying to understand what we did. Not the legal aspect, because Alex Whiting and Judge Ross, we discussed what's happening before the court. And that is more what the lawyers do. The thing that I think is needed much more debate, and it's connected with Catherine said, is for the young people it's normal, it's like for you, cell phones are normal. No, I did not use the cell phone when I was in university, not because I was stupid, they were not existing, okay? The world is changing, and it's similar, technology is changing. ICC is the only institutional innovation, the only. And that's why it's so complicated to understand. And my last 6 years trying to understand myself and trying to see how to engage in a debate. Because what I feel is it's like a black hole between lawyers talking about law. You know, there is no power in the courtroom. In the courtroom, Queen Process is the queen. Because she's the judge and she decides whatever she wants, and the judge and the prosecutor and the defense lawyers say yes. Or appeal, but the appeal chamber will decide. So in the political scenario, you saw what Karen was telling you. It's a different game. And the funny thing is the ICC is for the first time in human history, the decision to apply international criminal justice is in the hands of prosecutors and judges. No more political debate. And that Karen example illustrates the problem. Then you have international prosecutors, yes, can provide different incentives in the two-level game in the national setting, but of course they confront national leaders. Some of them, like President Santos, is committed to do justice, and then he managed properly. I was in Havana with the FARC leaders discussing why they had to go to the court. And they understood perfectly well the problem. So in Colombia, the funny thing is I apply all the same standards. In Colombia, without a case in court, the political leadership was in favor, and the national system moved well. In Uganda, at least we stopped the crimes in Uganda. Not all the 191 was executed. In Kenya, we transformed the defendants into the president and vice presidents. So the outcomes are different because they depend on the national people. And that is, for me, it's not just about court, it's about how political leaders manage the court. And that's what we're trying to do here. And I think the first conversation between us in the Carr-Ryan Center, I had to convince Matthias that in fact, the 20 years of the ICC is a progress on the ICC on the 7 years of the UN Human Rights Convention. Because basically, ICC is not promoting new rights, but it's enforcing international rights. That's the new thing. That's why maybe it's not a philosophical issue, but it's a crucial issue for the victims. Because it's not just about we're talking about principles, we're implementing the principles. And that is the big issue. And I had to find my way to explain to Beth and to Katrin, okay, see this, Katrin is talking about the justice demands. Katrin showed how the justice demands are improving, are increasing in the world. Thank you. And for me, the issue is how we can understand the justice delivery. Why there is justice in one country and not in another? What happened in Kenya? What happened in different countries? So I like to explain the justice delivery a little, and I like to discuss with Beth how we can measure the deterrence impact. So I'm trying to present the big picture. That's my plan. So my plan is, as Katrin said, Rome Statute is a new legal system. It's a new legal system where basically is confronting the war on terror. There are two models to manage violence that cross border. One is the Rome Statute, establishing some kind of international criminal justice and a confederation of states committed to prevent crimes and punish crimes. And the other group is the war on terror, which is basically a war declared by the US against non-states actors, functioning in 5 different countries. And these two models are started at the same time. The war on terror started in 2001, ICC started in 2003, so I was witnessing both. And what I like to do, more than present personal stories, I like to give you the big picture, if I can. So for me, the big picture is there are two options to manage violence: justice or war. That's it. You are enemy combatant, if you're a bad guy, you're enemy combatant, or you're a criminal. And it's a huge difference. And the funny thing for me is the space define who is a criminal and who's an enemy. Because at home, they are criminals. Abroad, they're enemies. The problem is when, for the US, Iraq is abroad. But for the Iraqis, Iraq is home. So that's the problem. You are protecting yourself, but you are affecting the Iraqi guys. And there is a problem with the foreigners. So Matthias, is for you. It's totally for you. It's a fierce urgency, because that is a great line Matthias developed. It's a fierce urgency of our Carr Center people to understand innovation on institutional technology. Here we're discussing technology. You have Thomas, the guy who wrote a book called Flat World. He had an entire book on the flat world showing technology changing our life, worried about violence, worried about war, and he did not mention in the entire book that this flat world is based on 194 different national states. So institutional designs are ignored. And that is a problem, because then we don't see the problems. There are, these little countries, but there are another 193 states countries outside. And then how to interact is something we have to discuss better. In particular, national states are not able to manage cases like Ijigo Adams, a victim of genocide in Darfur. That, Yana, can you show the video? They cannot manage with terrorism, organized crimes, and cyber crime. So all these crimes are crossing borders, and then the national state is not able to manage it. And I don't think that ICC is the solution. ICC is the first idea. It's like an iPhone number 1. We're in iPhone number 10 now. But we're still debating in institutional design, we're still debating iPhone number 1. Go. Yeah.
إذا سير كلنا إذا تدبيه غير إن إذا زاك كم تدبيه غير كلين توني كلين دوارا درين كسم باسم كلهم سيدورا سين أنصار كنا درين تنوي رستون يتكوي إيه أول جرام بيجينا إلى guru kata dari ini, kita hagar ni ya. Magar ya kita ingat kira itu, istilah dia hilang hilang. Wah kita nanti apa maksudnya kena kira ini kaya, dah kira itu kaya, bukan hal. Kita ada nasi dari dekat.
So she's my client now. She's telling us those who went to schools, I went to school. How to provide a solution for them. And you know, Darfur now is ignored. It's completely ignored now. Not because there is no power of ICC, because basically ICC was so powerful that President Obama took advantage of it to make a deal with Bashir on South of Sudan independence, important point, and the war on terror. And in fact, 2016, following the war on terror agreement, 2016, Sudan CIA opened an office in Khartoum, and Sudan joined the campaign in Yemen. And the last week of his tenure, President Obama proposed to lift sanctions to Sudan. So that's part of the deal. So the issue is the justice demands are very powerful, but not always produce justice deliveries. Depends on the political leadership. And that for me is the main point we try to discuss at the political science level, not in the court level. So there are two different issues. And to finish, to go back to the fierce urgency of innovation, Matthias, before you have to attend, and not for institution. I'm debating with them, because we discuss human rights issues, not thinking how we implement them. And I found that is complicated. It's not enough to discuss the principles. We need, Hishiro Adams need to discuss implementation. And just to explain the lack of innovation in technology, look, the first idea to protect citizens was ancient Athens, 6th century before Jesus Christ. The city border defined home, but Athens has no mercy with the enemies. To see this play how they kill all the guys in home. So national state took 23 centuries to go to iPhone 1 to iPhone 2, 23 centuries on institutional design. And, okay, the national state promote, if you read Steven Pinker, The Better Nature of Angels, Steven Pinker explained how relevant was the national state in order to protect people. Completely, he said, in the 5,000 years of history, is the most relevant aspect, the national state. However, national state also promote world wars. And that's the problem we have now. UN, UN was the idea to do agreement to stay in 5 states. Rome Statute is the next thing. Rome Statute is a confederation of states. So this is the topic. Here is the Rome Statute in blue as a subsystem of the UN system. In the Rome Statute, you have a confederation of states in blue from different parts of the world committed to prevent and punish international crimes. The white countries not. The white countries and the Security Council. Security Council can also use the ICC as a top tribunal like SPY, like in the Balkans. So basically, ICC is a piece, the court is a piece of the Rome Statute system, and it's a piece of the Security Council system. And my last point, before having taken my macro, is my question to Beth Simons. I'm delighted that Beth is with us. Beth has to help us to transform stories like Carr-Ryan or these legal designs into quantitative analysis. And my suggestion to her is she did a great paper showing deterrence, but she's not mentioning, or maybe I have to explain better, how the idea to start a preliminary examination play a role. And the Colombia case that Matthias said is very relevant. In Colombia, it was the best case we never did. And for Yugoslavia, the bombing in Yugoslavia by the NATO forces was the best case they never did, because it has a huge impact on NATO. So it's not just about what to do in court, it's about deterrent impact, and that was what the Beth is doing. But she's how to evaluate the different impact, how to evaluate this Kenyatta role or President Santos role, how to evaluate the different attitudes of the political leaders. That's for me what we need to go in detail, because that's a big difference. How we compare, she mentioned in her paper there are differences between Darfur and Libya and the other cases. And that is normal, because Kenya, even if against, Kenya is still part of the ICC. And President Kenyatta was a suspect, is still going to the court as a president, as a vice president. So they still pay some kind of recognition to the court. Bashir no, Bashir's committed genocide. He hates ICC. And in Libya is a mess. So I think it's very important to distinguish between the Rome Statute system and the other countries, the cases just in the UN system. And my final point, because I said from the beginning, the Rome Statute is a parallel system to the war on terror system. And in the same way, we need to improve the Rome Statute or create something different. My suggestion is we don't need to keep everything for ICC. We can do something different for terrorists, for instance. According to the Security Council, there's a good model in the European Union that implemented. It's a central prosecutor office in Europe presenting cases before judges in different countries in Europe. And we can do something similar with terrorism. We can invent something like in the US. In the beginning of the 20th century, you had no federal criminal justice system. Bonnie and Clyde escaped crossing the border of the states here. But then you create, you create the FBI, the prosecutors, federal prosecutors and federal judges, and you transform the game. We can do the same at a global level. And compare that with the war on terror. And to finish that, Stanley McChrystal, the general who ran Afghanistan in 2009, explained what he called the math of the insurgency. He said, because there are tribal communities and family communities with strong ties between them, the problem is when there are 10 terrorists in Afghanistan, we kill 2, how many remain? 20. Because the families and the friends of the terrorists became terrorists. So the numbers of ICC are not great, perfect, but compared with that, much better, much better. So we can invent something connecting both worlds. How we can use better our political efforts, our military effort, and our justice effort to really establish a world where the massive atrocities are stopped. Thank you.
Down is fine. I think okay.
I think it's there. I started.
Thank you. So in contrast to the other two speakers, I'm a scholar or researcher, and I don't have any relevant experience at all in this area. So I take refuge in data. So it'll be something completely different, but I hope that at least you'll find it interesting, at least pique some of your interest maybe of questions we should be pursuing. You'll see that they touch on many, many of the issues that both Karen and Luis have brought up here. First thing I just kind of wanted to just put up here, something we probably are all familiar with, and that is that the ICC has been subject to all kinds of praise initially. This perhaps kind of relates to the period of euphoria that the ICC could do something about the apparent spread of crime, international crime, and the related tragedies internationally. And I was going to put Catherine Sekink up for one of the most positive statements about the potential for the ICC, because I think her name is practically a synonym for an optimist with evidence. So, I was going to put that up, but I feel like there are a lot of places so we could get that kind of evidence about the range of attitudes about the International Criminal Court. And these are well, the first one there is an NGO, and then the other two are scholars. And Steve Krasner also had a stint in government as well. But I think there's some important context that we should keep in mind when we think about when the International Criminal Court was established. And that was, it was coming off a period of terrible, terrible violence against civilians. And so this kind of gives you a little bit of a representation of that period. What we have here is just data on one-sided violence against civilians around the world, and this goes up to 40,000 such deaths, and here's 10,000. So this is the number that have sort of been put together on average around the world. And I think what this suggests anyway is that it's pretty clear that there was a huge international trauma over this kind of global violence, and the thought that we could create principles and do something about it, I think, was really motivating the creation of this technology, this turn in technology towards justice. So it seems to me that this raises several issues about the International Court and its impact. And I just really do want to say that the expectations were terribly high at the beginning. And I think to some extent that accounts for a little bit of the disillusionment that is set in. But I do want to say one other thing about that disillusionment. I want to be really careful to supplement what Karen said about Africa. It is not just an African disillusionment. I think we need to be very aware of the potential for disillusionment in the West coming out of anti-internationalism and populist tendencies in the United States, and also in Western Europe for that matter. So it seems to me that populism is potentially against both things that the ICC stands for, internationalism on the one hand, and courts on the other hand. So let's just be aware that this is not sort of something that is only a matter of concern regarding attitudes in Africa, but I do think that there's a lot of skepticism internationally along these lines. But what does the social science research tend to say? First of all, let me be really clear that I am a scholar, I'm not a prosecutor. I think that a lot of positive things have come out of the International Criminal Court, but I never want to be put in the position of defending every decision that prosecutors have made, for example. Okay? So that is not my role, not my job. I don't see my purpose that way. I think the second thing is to really realize that news is not research, that we cannot draw conclusions about how the ICC is doing by looking at headlines. All of you know the biases involved there. I almost feel silly bringing that up, but I think it is so critical to realize that if we want to understand consequences, we have to look at broader trends than headlines. And then finally, I just want to point out that there are kind of three major clusters of research in the social sciences. The first is a deep dive into specific cases. And that work can be very qualitative and political and contextual, relying on interviews and relying on firsthand observation and information. And it can also be quantitative. So it can be a deep dive into social media campaigns, for example, within states that have to do with the interactions with the International Criminal Court. The second are general consequences of the International Criminal Court. And I kind of consider my work in this category right here, trying to think of what some of the broad consequences globally might have been. And I might add, on average, meaning that these consequences don't hold equally in all cases and in all parts of the world. Okay? They are efforts to try to document impacts and influences, but they are average impacts and influences. And I believe this kind of research must be supplemented with other kinds of research as well. And then this would be a really, really critical part of the research as well. If we get very radically analytical on trying to analyze what the International Criminal Court has done, we're going to forget that there's this really broad and important system of justice, which Catherine Sickink and her co-authors have worked and done so hard, and done a lot to expose and explain. So, what are some of the ICC consequences we can think about? One is deterrence, institutional and legal development, which is really very critical, the whole idea of complementarity, the idea that the International Criminal Court is part of a trend and has pushed that trend along towards the development of domestic institutions that can handle the sorts of issues brought up by international crime. The broader normative support, so we can look at the way that discourse and ideas have changed about what is appropriate behavior, and then we can look at measures of satisfying justice as well. So those are the kinds of things that we can do. One of the areas that I think is always, that I've really kind of done most of my work on is on the area of looking at deterrence. And here I've been sort of thinking about deterrence in terms of being a function of the likelihood and the severity of punishment. So this is a very traditional way of thinking about deterrence. And when we use a model like that, we can just sort of think of a hypothesis in which the ICC jurisdiction deters because it raises the likelihood of punishment. Compared to what is always the question. Compared to what existed in the absence of the ICC. Compared to impunity in many cases, compared to highly biased political justice in other cases, and I presume in some cases as well, compared to good modes of domestic justice and strong modes of domestic justice. So we need to always, always, always be thinking about related to what. And so the research that I've been trying to do, and I've spent a few years doing, I haven't worked on this lately, so it is not right up to date, but it was up to date as of about 2 or 3 years ago, is that I would look for evidence that expansion of the ICC's jurisdiction and evidence that it was going to be investigating and seeking to hold people accountable would actually reduce a very important measure of something we care about, and that is that civilians should not be intentionally attacked. Okay? So in other words, precisely the video selection that you showed us is the intentional attack of civilians. So one thing that this research is showing is basically that joining the jurisdiction reduces state attacks, okay, on civilians. It does not deter rebel attacks on civilians, according to the evidence that we were able to analyze. That adoption of ICC consistent legislation via complementarity, so in domestic statutes, also and to an equal amount, reduces state attacks with no effect on rebels again. Okay? And these are intentional attacks on civilians. And then finally, when the ICC starts investigations, then attacks on civilians fall both from states doing the attacks and from rebels doing the attack. And this is, I think, what you were suggesting with the importance of preliminary investigation. And can investigation be used a little bit more explicitly as a way to influence strategies being chosen in conflict? How might this look? And I just want to show you a little bit of data here. What we have here is the case of the Lord's Resistance Army during this time period. These are attacks on civilians with the dark line. These are battles. So a couple things you can see here. And then we have the years here. This is when investigations begin, ICC investigations begin right here. So one thing is very clear. The International Criminal Court does not eliminate violence. It doesn't eliminate violence. You know, so, okay, let's grant that point. And in fact, we'll say something different, and that is that violence has actually gone up in some ways, right? So intense violence has gone up to a certain extent over the last 2 decades. But the proportion of civilians being intentionally attacked has gone down. So the way that we fight, not we, but the way that fights go on, is that they are actually getting somewhat less violent towards civilians. And this is what you see after ICC investigation right here in the Ugandan case. So what you see here basically is when you have the dashed line, which are the battles exceeding the number of attacks, when you see a relative shift in those two things, you should at least think through how that can be connected with the idea of ICC investigation. So that's just sort of one little way that we can think about deterrence, the deterrent effect. The second thing to be thinking about is the institutional development that the ICC has given rise to. And so this just gives you sort of a sense of institutional and legal development. This is the number of states worldwide, that a cumulative number of ICC consistent crime statutes reforms, how many states have made those kinds of reforms. So you have basically down here domestic law that doesn't reflect the law of the International Criminal Court, and then you have a growing number of those states over time. Very important part of the institutional development in context. I think something else is kind of interesting and suggestive. I don't know that there's anything causal going on here, but I think I want to show you something else. What does it mean if we say, does the ICC change norms? What would that even mean? How do we even measure a norm? I'm not sure we know how to measure a norm exactly. But norms might be related to language. Of course, language can be used cynically, but let me show you something kind of interesting. What I'm going to show you is a set of 2 word clouds. These word clouds are drawn from rebel documents that are collected by an NGO called In Their Words, and they collect these documents about the kinds of announcements that rebel groups are making. Okay, and so here we have two word clouds here. One in 1981, one in 2014. It looks like something is changing over time here in the content of the language that rebel groups are starting to use in their documentation, their announcements, their internal rules to some extent. These reflect internal rules as well. So this just sort of gives you another kind of sense of that. What we have here are the percentage of words in dark solid line that are related to human rights or humanitarian issues. And we have in dashed lines the number of words, the percentage of words that are related to political demands of various kinds. And you can see there's a tilting in that a little bit over time. So maybe norms are changing. Now I want to show you the evidence on what we have about satisfying justice. Okay, next. So we have no evidence on that, basically. So that's my point. We don't have hardly any evidence on how people experience the justice of the ICC, or the justice of holding leaders accountable. But we do potentially have some information on backlash, and I'm just about to wrap up here, because there are a lot of claims being made about backlash, that it is on the rise, that it's insurmountable, and it's undermining accountability. But what does backlash signify? I think it signifies a response to changing conditions. You don't lash back against something that has no consequences, no threat, and no effect. So I think that we can at least suggest here that backlash signifies something's changing. Accountability is changing. Who is lashing back and against what? And now this brings me to Karen's comments, which were very, very interesting comments. Because she really had the discussion about the diplomatic discussions about support and elite Kenyan support changing over time for the ICC. And I just think we should be thinking about some of the evidence that's below elite level as well when we think about the International Criminal Court. So this is in, this is in 2010. I don't pretend to know Kenyan politics all that well, but we can see when the question is those who support trials in the ICC process by province. You can see there's some big differences by province having a lot to do with politics. But this is suggestive of a fairly high support for the ICC. And in fact, you can see a lot of skepticism. You always need to compare to what, right? So if you want to compare it to sort of another sort of source of justice, we might be thinking about domestic sources of justice, which here is quite low in the Kenyan context as well, which is quite reflective of Karen's discussion as well. Now, let me just say just a couple of other things that I would just want to conclude with very quickly. First of all, we have huge gaps in our knowledge about the International Criminal Court. We have gaps, I think, but one of the main gaps we have is between the aspirations which were set out for the courts initially and the actual reality on the ground. We have huge knowledge gaps. So in other words, that blank slide that I put up, we have really very little sense of how justice is experienced on the ground when the ICC gets involved. We also have conversation gaps. So I don't know, but it feels to me like it's quite rare when we have a room that includes both African scholars and thinkers as well as Western scholars and thinkers in the same room. And so I was really pleased to have Karen on the panel today. So I think that's another thing that I think ought to eventually be addressed. I think there are at least two kinds of threats that we need to keep aware of. One is the rise of Western populism, but also the idea that these narratives of resistance to the ICC are very, very elite in many ways. And we need to at least be aware that those who actually experience the justice of the ICC might have different points of view. And then finally, I just want to think of just a couple of research opportunities. I mean, so much work to be done in this area, doing more to measure norms, doing more to measure attitudes and the legitimacy of the International Criminal Court. It is clear to me the ICC needs to work on outreach. It needs to do it in ways that don't seem like a hegemonic kind of a Western institution and work hard on the issue of complementarity. It's not like African countries don't understand what a court is for. They do understand, of course. You know, and it seems to me that this idea of kind of relying on to believe somehow that the ICC is the only answer to legal justice in Africa, I think actually does smack a little bit of Western imperialism. So it seems to me that there are huge opportunities for encouraging this complementarity.
So I want to get the panel back up here. I want to get the panel back up on lights on. And we're going to have some time for question and answers. You know, after this session, we are going to have lunch, so let's have time still for some questions. While we're waiting for a question or comment, I saw fun down here, and I wanted to say that Beth's last point about not enough kind of knowledge of what people think on the ground. So Fang Fang is a faculty member here at the School of Public Health. She's one of the leading experts in the world on surveys, victim surveys, including asking people about justice. And I wonder if you would just have a few words to share with us about the gap that Beth was talking about in terms of knowledge of what ordinary people may think.
Yeah, I didn't know I was going to answer this question, so I didn't prepare any numbers, but I can tell you about northern Uganda. I think, as you know, we did 3 waves of survey, one in 2005, and then that was when you just announced the investigation in northern Uganda, and then another wave of data collections in 2008. That was when they were negotiating peace, and another one, I believe, in 2010, right after the LA left the region, really. And the knowledge of the ICC increased, and that they did tremendous amount of, and I think the perceptions and the receptions of the ICC also increased throughout those 3 waves. I think there was a lot of discussions in 2005 whether the investigations of the ICC in the situations would actually interfere with some of the peace negotiations, and also whether the Acholi people accept Western types of justice, because there was a lot of discussions about the Acholi cultures and their ways of resolving conflict locally in all the place. And I think so there was a lot of debate about that. And so when we did the surveys, people were split between the 2 processes, one that was traditionally used and then this new intervention. And I think as people learned about the ICC, their receptions of the ICC also increased. So I think that's the biggest case that I could talk about. But I think in DRC, we are also seeing some increase in receptions of the ICCs, especially now that there's been a few cases that has been resolved in that cases too. But we're seeing an increase, I think, demand as well for international justice as well. So I think that's been a major shift that we see in our data.
Yes, we're open. So.
Hi, thank you so much. I'm Flávia Piveza, I'm a professor and a visiting scholar at Harvard, and I'm also a member of the Inter-American Commission on Human Rights, and I have 1 comment and 2 questions. The comment, and I think it applies to Inter-American system as well, is how much impact goes beyond the compliance and the implementation of specific decisions. So it was really, for me, fascinating to learn about the peace process in Colombia, how the ICC made a difference on that, the impact of the preliminary investigations following the violence, and also fomenting change, legally and in terms of institutional change. But my first question has to do with principle of cooperation, because I think, although I do agree, and I'm a believer on ICC and in international justice, and in the second level of justice game, I think the second level depends on the first level, depends on state actors. That's the paradox, because according to the your experience, the experience of Kenya, you have tensions, and this is such a delicate balance, complex balance between tension and collaboration, support and resistance. And regarding the African landscape, I'd like to hear more about this optional protocol to the African court with the goal of expanding the criminal jurisdiction of this regional body. And I see this as an indicator of facing the jurisdiction of ICC. And my second question has to do with the voice and the victim approach, especially concerning the reparations, because we know that ICC has two ambitions: to deal with crimes, justice, but also looking at the victim and the reparation approach. Thank you so much.
Probably I'll just speak in relation to your last question regarding the African protocol, or rather the protocol to the African Court on Justice, which basically expanded the jurisdiction to include ICC crimes, what we call ICC crimes, genocide, crimes against humanity, and war crimes. But of course, it goes beyond that. It has corruption, it has terrorism, so it has a much broader mandate. And I think we have to remember that this protocol, or rather the agitation for this protocol, actually happened at the time when there was a serious campaign against ICC within the African Union in Addis Ababa. And since I think 2009, from the beginning of the case against the president of the Sudan, every year the African Union has an annual assembly of the member states, and they adopt resolutions. And since around 2009, every year they have a resolution on ICC. And that resolution, of course, the main message in that resolution is to urge African states not to cooperate with ICC in the arrest and surrender of President Bashir, and later on, of course, the President of Kenya. And it was in the course of those discussions that they actually started saying, we don't need to go to ICC, we can have our own court to deal with these cases. That's because part of the African Charter, there is a provision there that basically says that Africa will combat impunity. So to show that they are really complying with their charter, they cannot say we're pulling out of ICC, then what is the alternative? So then they argued that instead of submitting to ICC, let's form our own court. They already had the African Court on Justice and Human Rights. So what they did is adopt a protocol expanding its jurisdiction to include ICC crimes. So it's, now the problem with that, and when what makes me think that maybe it was not a genuine effort to give jurisdiction to this court, is that immediately after it was adopted, I think it was adopted maybe 4 or 5 years ago, no single African state has ratified it. So it remains there on paper, but nobody is really moving forward to implement it. I think only 3 have signed, and no single African state has ratified it. And it can't enter into force, I think, until it gets about 15 ratifications.
So I may answer the question on the victim reparation.
Oh, maybe this.
The victim reparation. On the victim reparation, it's a difficult matter, not working very well. Still in the process, probably keep process, and I think we'll discuss that more. I do not know, but I think it's a new process. On the cooperation state, which is a huge issue, that's for me the issue I like to understand how to present properly. Because here in the academia, the scholars like to isolate variables. And I was pushing back to discuss the determinants of the war on terror, but she didn't mention that. Because it's like a different, they are human rights people, not war on terror people. So, but for me, they are totally connected. Kenyatta was supported because he did the war on terror in Somalia. So, and Obama used that warrant against Bashir to promote a peace agreement in the South. And I saw the connection. I need to learn how to present properly. And then I think complicated to present these political interactions. And maybe one example to present properly. The Tanzanian president was lobbying me and the president of the court in 2010 do a case in Kenya. Because if not, in the next election will be a disaster in Kenya, and if Kenya collapses, Tanzania collapses. We cannot resist the economic backlash, we cannot receive the refugees. So he was insisting, do a case in Kenya. Okay, thank you. One day, we did a case in Kenya. Everything was fine, as Karen said, when I announced the intervention of the court. In that moment, it's no problem. Everything was happy. I announced the opening with the president of the country and the prime minister of Kenya, together in the presidential palace. Everyone was happy. When I indict the guys who had to be indicted, everything is different. Because they don't like to be indicted. They don't like to be prosecuted. Then you're clashing the political leadership. And then, what happened was, there was an African Union meeting. Bashir was moving African Union with Gaddafi. Gaddafi, as the chairman of the African Union in Sirte in 2009, was the guy who in the last minute of the African Union meeting introduced the clause that African Union should not cooperate with ICC when they're head of state. It was Gaddafi himself, in the last minute, no one was there. Uganda was trying to oppose it, Uganda stopped it. And it's funny because Gaddafi was plotting against Bashir. But in any case, all of them are head of state, so they protect each other. So Gaddafi was the first, Bashir was the second, moving African Union. And in 2010, when we indicted Kenyatta and Ruto and the Secretary General of the government, suddenly there was an African Union meeting immediately after. And I saw Tanzania would be the second speaker. So I said, okay, it's a great moment that Tanzania was pushing us to do the case in Kenya. Tanzania had to be able to support them. So I called Kofi, because Kofi Annan was my dream. Kenya was my dream, because Kofi Annan was the mediator, a brilliant guy. So I called Kofi, can you call the Tanzania president to tell him to support us in the African Union meeting? And Kofi said, Luis, I did it. I was yesterday in Davos with him, I told him. He told me he would do it, don't worry. Fantastic. So, happy. African Union meeting, the Minister for Affairs of Tanzania denouncing ICC intervention in Africa, against Africa, the prosecutor, blah, 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 blah. So I became ballistic. I called the president of Tanzania myself. I said, President, what you are doing? You told me how to do it, you supported me, and now you are attacking us. Don't worry, prosecutor, we love you, we need you, but you have our full support. The problem is, it's the beginning, the first day of the African Union meeting. They just want our words, nothing else. We never decide something against ICC. But you know, in Africa there are these 10 head of states against ICC because they are committing crimes. That's why we need you on board. But we cannot discuss this issue properly with them. That's why when they ask our board, we say, yes, we attack you. But we support you, don't worry. Nothing will happen. So how you transform that into data? All of you do quantitative analysis. How you can transform this type of management into data? That is one of my problems. How can I transfer my experience into data? No? That's the problem.
And hold the mic closer.
Okay, so it's kind of interesting that how much confusion there actually is. Again, if you look at public opinion data, confusion over reparations. I'm thinking of the Colombian case here, because the Colombian peace agreement is so complex. It has a huge justice component, it has a reparations victim-centered component, and it has a development component to it. And when research is done on how people get some kind of a payment or some kind of compensation, they're not sure what it is for. Sometimes is this a development project, or am I getting compensated for something in particular? And there's confusion over that. So I'm going to at least put a hypothesis out there, and that is that when you have both the justice component with prosecution paralleling, or maybe it doesn't even have to have prosecution, but a clearly articulated justice component paralleling the reparations, people will understand better that their justice issue is being addressed through this kind of a compensation, rather than confusing that with other kinds of transfers that may not address their justice needs. So I think that's something that I think is perhaps a lesson of the Colombian case.